Got it. Great. Okay. Welcome everyone to the series Speaking Up for Point Molate, in which invited speakers address key issues about Point Molate and members of the public can ask questions. We acknowledge that the East Bay is unceded territory of the Chochenyo-speaking people of the Muwekma Ohlone tribe, who are the traditional stewards of the air and land and water. We recognize the importance of this land to the Ohlone people, past, present, and future, and we invite you to join us in learning about and honoring Ohlone history, work, and culture. The speaker will present for about 40 minutes, and then we'll answer the questions. Please limit your questions to 1 minute. We invite sincere questions asked with courtesy and respect. You are also welcome to put questions into the chat as they occur to you. If you would like to raise more complex issues, please put them in the chat as well so that we can consider them for future sessions. And though issues around Point Molate can be contentious, let's be polite and courteous. Also, please use the chat to let us know how we can improve. Once we get started, I will put the link for the Speaking Up YouTube channel into the chat in case you would like to see recordings of other sessions. My name is Sally Tobin. Pam Stello and I are co-founders of this speaker series. I'm a biologist and retiree of the Stanford Center for Biomedical Ethics. I work with the Point Molate Alliance and the Richmond Shoreline Alliance, and I belong to the Bay Area Sea Kayakers. I serve on the board of Citizens for East Shore Parks and live in Richmond. Pam Stello is co-chair of both the Point Molate Alliance and the Richmond Shoreline Alliance. She also serves on the board of Citizens for East Shore Parks. Pam lives in Richmond. Please wave, Pam. Our Zoom administrator today is Guillermo Calderon, who is a recent graduate of UC Berkeley with a degree in society and environment. He is a lifelong resident of Richmond and is excited to take part in this series. Please wave, Guillermo. Thank you. Our speaker this evening is the eminent attorney, Robert Cheasty. Robert is recognized in Super Lawyers of California, the top attorneys in Northern California, the best attorneys in America, and the National Trial Lawyers Top 100 Trial Lawyers. Robert serves as the Executive Director of Citizens for East Shore Parks, or CESP. CESP is the organization that practically willed the McLaughlin East Shore State Park into existence. Robert has been involved in the effort to create a park at Point Molate for about the last 2 decades. Tonight, he will explain the recent major court victory that brings Point Molate closer to becoming a public resource and a regional park. So here is Robert Cheasty.
Good evening. Hi, thank you, Sally, for that very nice introduction, and I'm glad to be here with everybody tonight. This comes on the heels of an amazing victory. We've been working on this. When I say we, I'm one of a team of lawyers that worked on this case. I had the pleasure of working with Stuart Flashman, who is a really deep thinker and a wonderful guy to work with. He's a great lawyer, and he was the team leader with Norman LaForce, who is another really powerful lawyer that I got to work with, and another gentleman named Steve Volker, who represented other clients from the ones we represented. And it was an honor to work with them. It was really a fun thing to do. Anyway, where we are today, though, up until now, we've been dealing with a trial court. And the judge in the trial court is what I would call tone deaf to arguments regarding environmental quality, and in CEQA in general. And he ruled against us, and so we lost at the trial level. And that was disappointing, but we appealed. And the Court of Appeal overturned the trial court and gave a disposition. There was a judgment, a very long judgment that had lots of findings. The court was very thorough. They disagreed with some of the arguments we made. They agreed with some of the arguments we made, and they made a ruling and came up with what's called the disposition. There's a judgment, and then there's a disposition. And the disposition was challenged by the city of Richmond and by the developer, which is a silo. The way developments are done in this particular world is you get large companies that do lots of developments and they create little independent silos such that if that silo and that project goes belly up, it doesn't affect the rest of the company or the investors. So this silo is called Winehaven Legacy LLC. And this silo is basically an empty shell with the bare minimum of assets necessary to operate as a corporation. Anyway, that silo, if you would, or I'll just call it the LLC, is the entity that represents the developer. So the city and the entity representing the developer, they opposed what was done at the Court of Appeal. And for those of you, let me just set a few ground rules. First, I know we'll be speaking to lots of people who are interested as members of the public. And so I'm just giving you what happened from our legal team's point of view. And what I'd like to do is to assume that people have some knowledge of the court structure, but not a lot. And so I will try to make this very clear and not drop into a lot of legalese with a lot of abbreviations and acronyms so people can't follow what the hell I'm saying. Anyway, so there was a tentative ruling put out by the court. The tentative ruling is what courts normally or often do before they issue their decision, and that gives the lawyers a chance to say, we'd like to come in and argue. And so that's what happened here. We got a tentative ruling in our favor. The disposition basically said that because of fatal flaws in the EIR, the SEIR, and I'll tell you what that is in a second, but because the CEQA study that was done was fatally flawed, you're going to have to disallow, basically totally set aside your approval of the SEIR, and you're going to have to set aside all of the development approvals that flowed from that. That's a complete victory in a case like this. And so the city came in and argued, and the developer came in and argued, saying, no, don't do that. And they made some other suggestions, put it through a process so the lower court can try to see if they can tease out any parts of this development to go forward. And we opposed that approach, which was marginally successful with the court. The court wrote a final disposition that was, we think, inaccurate based on the state of the law. And we wrote to the court and asked for a rehearing on that. So basically, we're having an appeal, and then sort of an argument over the results of the appeal, and a decision, and then sort of almost like another appeal of that back to the court. And this second request for hearing we put into the Court of Appeal, we suggested that the lay of the law was not the way it was presented by the development lawyer and by the city lawyer, and that they raised some arguments that had never been briefed before or discussed, and we wanted a chance to do that. And we pointed out the flaws, basically saying that you can't, in a case where the main flaws in the EIR are so egregious that they can't really be fixed or teased away, then you can't do that process. You simply have to say, I'm sorry, the development proposal that came before you and the EIR that supported it, both of them, the EIR has to be rescinded, and the development proposals that flowed from that have to be disapproved. And that's the final thing that the court did. It said, look, we're not going to hear the requests for rehearing, since both sides came in and tinkered with what they wanted done. They adopted our language and made that the final disposition. And as of today, which is days after the cutoff or filing an appeal to the Supreme Court in California, there has been no appeal filed. So absent some unusual and very bizarre circumstances, this is it. This is the final ruling. Basically, we won. So EIR, oh, thank you. We should clap. This is a group victory. I mean, this was an amazing victory. And people have been working on this for 20 plus years. I remember the first meeting I had on Point Molate. There are a number of activists in the community, and two of them are the Smiths. And we used to meet at their kitchen with Carol Tilchik and Tarnal Abbott and Margaret Grady and a couple of other people, myself and Norman LaForce. And we used to talk about, well, wow, what a wonderful thing it would be if Point Molate could be turned into a park. And we were from those simple like beginnings, here we are with an amazing thing. So let me stick to the law parts because I have other anecdotes to share with you regarding that. CEQA, that's the California Environmental Quality Act. In other words, many years ago when Jerry Brown was first governor, there was a thought that, when you're doing major developments that impact the environment and the community, you should have to do a study first that shows what those impacts will be, so that when the cities actually look at these things and the counties for approval, they have a chance to know in advance what the impacts, in particular the negative impacts, will be. So if a development is going to allow for destruction of vital environmental habitat, or massive risks for fire, or destruction of sacred spaces of Native Americans, or a bunch of other kinds of concerns, traffic impacts and the like, those things should be known before the city can go forward. And that's what the CEQA process is, the California Environmental Protection Act. And when you do that process, it's called the California Environmental Impact Studies is what you do. And then you issue an environmental impact report. And that has to be done for a city to consider and approve a major development, as with what we did here in Point Molate. So the city chose to do a project based on a settlement of another lawsuit before this one. And not to get too into the weeds about that, but there was a casino development proposal proposed to the city. And that casino development had an environmental impact report attached to it. But that casino development never went forward, primarily because the community did an advisory vote and opposed it. And so there was an election in the city of Richmond, and the composition of the city council changed. And I think that what happened to the city council was less favorable, especially based on the advisory vote of the people. That I think it was maybe 60% against the idea and 40%, something of that nature. And so the city chose not to go forward with the casino proposal. And because the agreements regarding those approvals and the tentative approvals and the agreement to allow the developer to have exclusive right to present to the city a project such as the casino development. Well, when the city actually entered into those agreements, this is a rabbit hole I won't go down, but the conclusion of the rabbit hole is that there was an understanding between the developer and the city that when the city accepted money from the developer for these exclusive rights, that it did not have to give the money back in the event the development didn't go forward. And the developer then turned around and sued the city, the developer and the gaming tribe, the Giddyville, that was the tribe that was going to facilitate turning this into a casino. They sued the city and they wanted their money back, and the city said, no, we're not going to pay you back. And the city won at the trial level, but the city lost at the appellate level on some very technical grounds. Not that they lost, but that what the court said was there are some triable issues of fact that have to go before a jury. You can't win on a summary procedure. That means that a summary procedure is just what it sounds like. The one party says, well, look, if all things are equal and everything that they say is true, we still win because under this set of these set of laws, codes, or agreements, there's no way they can win. And so we get a summary procedure. And that's what happened. The trial court said, yeah, this is a summary procedure. It's sufficient. You're done. You won. And the Court of Appeal in that case said, no, it's a triable issue of fact as to whether or not the city did anything to thwart the casino developer from fulfilling its obligations and therefore going forward with its project. That's a very long in the weeds explanation, but what it meant was there was this lawsuit hanging over the city. And that lawsuit, according to the city's attorneys, prevented the city from going forward with any planning or development proposals or bringing the community together about its own choices for development. They had to wait till the end of this lawsuit. And in the meantime, there was some shift in the political alignment in the city in terms of who got onto the city council. And the new mayor was pro-development, and he went in and settled with the Giddyvilles and the casino developers under a proposal that was then, and they were sued in federal court because they were involving a federal tribe. So this particular settlement agreement was then turned into a judgment. That court where you have parties fighting with each other, they agree to something, they say, let's put it on the record or make it a judgment. The courts will do that. So it became a federal judgment. And according to the federal judgment, there were certain things that the city would then be obligated to do. For example, obligated to allow for a certain level of housing development and a certain level of commercial development. And the deal was that the money would then be split. The project, there would be a sale of the property to a developer with these kinds of agreements and proposals, and that the money would then be split between the developer and the city. They had to later modify that judgment because we challenged it and said that's straight up a violation of CEQA. You're requiring the city to approve something they haven't even gone through a process with and reviewed. So they modified the judgment to say that the city would be obligated to review proposals. And in a sense, the way the law operates, they wouldn't be allowed to unreasonably deny them as long as they followed certain guidelines. That's critical to note because right now, what happened with this case is the disposition of the Court of Appeal case on our case, not this earlier federal case I was talking about, but our case. It disposed of the EIR. So the environmental impact report now is no longer valid. Not that the Court of Appeal did that, but the Court of Appeal said to the trial court, you have to tell the city to do that. So now the city is obligated to disallow that environmental impact report and all of the approvals that went with it and followed from it. And that would mean that now the city has no longer any obligations with regard to Point Molate. And that might be disputed by some of the people who are advocates for development out there, but it is the decision of the court. So, for example, there's another lawsuit against the city right now. It's this shell corporation, Winehaven LLC, that is suing the city because it claims that the city unfairly didn't allow them to proceed with a very large development out there. Now, the merits of that, I think, are very much against Winehaven. The city bent over backwards to allow them to do what they were allowed to do. But the important part of this is that even if they were right, even if they could somehow prove that the city interfered in some way or didn't make it easy for them or whatever, there are no damages because what our case did, this Court of Appeal case did, was it removed the environmental impact report. So there is no environmental impact report, and it removed any of the approvals that happened. So whatever environmental impact report that this Winehaven LLC had, and whatever project approvals it had, are all gone. They own the rights to nothing. It's like a toothless tiger. So their lawsuit has no validity. And I think with proper legal representation, the city should be able to get that lawsuit thrown out. Now, going back to the other issue, which is an important issue, the federal case, the earlier one I was talking about, involving the Gideville and upstream, that agreement that was achieved by a very aggressive pro-development mayor in Richmond and kind of rammed through all of the commissions and committee hearings with his appointees. That agreement is basically the city has to cooperate with that agreement, but there's no longer a proposed development. There's no longer a development that has any entitlements. So what is it that they have? And that becomes a big question now, which I guess will lead me to close to the end of the part of the program that I think I want to make in terms of presentation, is I think where we are now is that the city would be in fair shape to look at what it wanted to do with regards to a reasonable proposal to do a development plan out there. And there are two parts. First is the part that my organization, Citizens for Shore Parks, is involved in. And we want to see a park out there. We want to see a park along. Our goal, if you would, is to see a linkage of parks and open space along the shoreline such that you would have a shoreline experience from Crockett to San Jose. The East Bay shoreline would be linked together. I acknowledge that there are some exceptions. We have the Port of Oakland. Nobody's asking the Port of Oakland to ship out and move. Well, and we have the Port of Richmond. I mean, you make accommodations, but there are a lot of spaces where it would be preferable to allow for park and open space and move a development further inland. For one thing, there's the very practical problem of sea rise and the rising water tables, which are going to converge on the waterfront and make it almost impossible for people to be able to function in the way they have been in the past. So there's that. But in any event, that's our interest, the Citizens for Shore Parks, and that's one of the organizations I represent. And maybe I should say for a moment that the organizations that joined in this lawsuit that had its victory were Point Molate Alliance, which was an organization formed by many groups and individuals to actually represent this interest in protecting Point Molate, and a number of strong environmental organizations that went with it, including Citizens for Shore Parks, the one I'm with, the Sierra Club, Sprawl Deaf, which has been involved in litigation for protecting habitat and trying to concentrate development along transportation corridors and things like that. The California Native Plant Society, Audubon Society, Golden Gate Audubon, although they're not called Audubon now, they're called Golden Gate Bird Society, I think. But and two or three others. There's Blue Frontiers active part, and I'm going to miss a couple of individuals. There are a bunch of stalwart individuals who put their names on the lawsuit, including Jim Hansen and Pam Stello and Tony, I guess, Tony and his wife, Margaret. I can't remember all of them. Then I'm going to skip somebody, so please forgive me for not giving them. I should have had a list in front of me. But these people are the kinds of people who are willing to put themselves out for the community and to step out. Leadership is a hard thing to do. So kudos to them. Thank you very much. Here it is. It's the San Francisco Bird Alliance. Thank you. That's from David Helborg, one of the stalwarts involved in the Point Molate Alliance. But so the other part of this is there's a Winehaven village there. And everybody agrees that the Winehaven village should be revitalized. It needs to be put to good use, good purpose. And there should be a planning process in Richmond that allows for that to happen. Because of the lawsuits, and in particular the Gideville and upstream lawsuit, the city felt based on advice of counsel, that they couldn't go through a process to do any real serious planning. So that it never happened, which is really a shame. I mean, for a city like Richmond, which is a vibrant city with a lot of incredibly creative people, that they didn't get to do that was, I think, a loss. And every time they were getting ready to do it, somebody would say, well, here's a development thing. That's all we can talk about. And that's what happened here with this current proposal that just got shot down by the Court of Appeal. So where we are now is we have a park area that is perfect for a park. And we have an area that calls out for some kind of creative development, the Winehaven Village, and it should be restored. And that's basically where we are. I think the city now will be able to proceed and look at that and decide what they want to do. I don't represent the city. I'm not a lawyer for the city, so I don't give them legal advice, or at least they don't pay me for my opinions. But that I think will be the process going forward from where we are. So that's kind of like if you would, a thumbnail sketch of the litigations that we've been involved in and where we are. And I can tell you that if I had the other lawyers on the panel with me today, you'd hear another half hour of lots of other nuances that they would add. But I think we would come to say that this is a reasonable presentation of where we are. So with that, I'd like to turn this back to the moderator and see if people have questions. Good, no questions? Well, I guess we
You
our
wish.
break.
Okay. I just had to unmute myself. Okay. So thank you, Robert. That was wonderful. And Pam will be handling the question and answer period today. Pam?
Yeah, hi, Robert. That was wonderful. Thank you. I'm going to check in for raised hands, and I'll also be checking the chat. And when you're recognized to speak, you'll have a pop-up window on your screen and you can unmute yourself. And we don't have anyone on the line that's on a telephone. So everyone can use the raised electronic hand, which is often under reactions. Any questions?
Well, I guess I was pretty thorough.
Oh,
I have a question.
okay, and go ahead.
This is Nina Smith. So what about the fact that under that settlement agreement, the property was sold to the Winehaven people? What's the impact on that from this court decision?
Sure. So thank you for listening in. Good to see you again, Nina. You were one of the people who really helped launch this boat. So how the property came back to the Giddyville was one of the really weak parts of the settlement agreement that the mayor and council entered into to settle that lawsuit. It was, frankly, it was really bad. If I could say, just as an aside for just a second, once you've served in city government and once you've served as a mayor, and I've had the opportunity in my community to do that. I live in Albany, which is basically shares a shoreline border with Richmond. You learn that there are processes that you want to follow to engage the community, bring people together, so that you want to bring them together so that you don't have this kind of blow up that happened here. So one of the really bad parts of the deal was that if the city was unable to process all of the approvals and get the property sold, well, it was in charge of the property. And when I say property, I'm talking about all of Point Molate. Then the city had to turn around and sell parcels back to the Giddyville Upstream Group at $100 a parcel. And there were 4 parcels that were sold back to them, not the entire property, but basically the developable parcels, at least the parcels that were considered to be developable. There was an agreement, and Pam and Sally can stop me if I'm getting into too much detail here, but I think it's important to note that there was an agreement in the settlement of the federal lawsuit that required the city to move with certain speed to get this done. They had 4 years basically to do it, and they failed to do it. They failed in part because the process was flawed, and they didn't do the kind of spade work it took to bring people together to get some forward agreement. And they also failed because they picked a developer. They had a little, I don't know what to call it, sort of like a show pony opportunity for developers to come in before the city and say what they would be able to do. And the developer that the city picked was not the one that anybody at the meeting thought might have a shot at it. I mean, at the end of the meeting, all of the city council members were commenting on the various presentations. And the weakest one was by a company named SunCal. And they seemed to agree in the meeting that SunCal was pretty much out of the running. But somehow SunCal met with the mayor, and a couple of meetings later, SunCal got the bid. So anyway, they weren't able to get through the process and come through the development process and sell the land to SunCal. SunCal failed heroically in major part regarding the finances. It could never get it together to show the city that it could go forward and finance the deal and actually have the money to make the deal go through, because Point Molate is a very complicated site, and it requires, depending upon which of the city estimates you use, but by the city's estimates, it ran anywhere from $350 million of needed infrastructure before you could even start to anything on a particular building. So it ran between 350 and 500 million in terms of infrastructure. And my organization, SAS, spent some money, and as part of our litigation prep, we went through with 2 different developers to see what it would cost and whether the project made any financial sense. And from what we could see, and what these developers said, no, it didn't. And these are big time developers, like people, international developers. They said that it doesn't pencil out. There's no way this can. So we offered that information to the city, and the mayor said, no, we don't want to hear from you, basically, uninterested, no thanks. We have our own inside people that we want to use. But you see, the problem was that because of this real cost, the city backed away from being willing to have its good faith and credit used as a backstop for this in case the project failed. And the developer refused to put up its money. And so they couldn't go forward with an agreed upon price of $45 million, which they had agreed upon. They couldn't come up with the money. So the development never went forward. So as a result, at the end of the road, the time clock ran out, and the city was obligated, because of this terribly drafted settlement agreement with the Gideville and the upstream, to sell the property for $400 to the Gideville and upstream. Now, it wasn't an outright sale without any.
Oh, Robert is frozen.
The rights to the property and have to sell it, and they may run out of time. So that's basically where we are. That's how the $400 sale happened. It was because of Tom Butt's terrible deal.
Thank you. We have 3 raised hands, and unfortunately, I don't know who raised their hand first, so I'm going to go actually in order that the hands are presented. So I'll go with Debbie, and then Gail, and then Gail Eyerweiss. And I believe it's Gail Seymour. So Debbie Baer, Gail Seymour, and Gail Eyerweiss. Debbie?
I put
Okay,
it asleep.
here I am. Nina, I appreciated your question, because I'm confused about that too. And Robert, I understand you went through the history, but what does it mean? I mean, the outcome. I understand how we got there to these parcels and the $400, but what position does it put us in now? is one question. And then the other question is what's going on with the park and how likely it is that, do we need money? Can we raise, do fundraiser like land trusts do? And then my final question is, because we keep saying the Giddyville, but it's a Giddyville and upstream,
Yeah, it is the Giddyville and upstream.
And I don't know how to parse them out. How much is it Giddyville? How much is Levine and his people? Because I think they had a lot of. If anybody put money in, it was probably them, their side. So, right, I don't know who has the claim, upstream or the Giddyville, and why we keep saying the Giddyville. And which also on my mind always raises this question that I've had: is there any way of cutting in a deal with the Giddyville or with the Segoria Land Trust so a portion of that land can be rematriated with them as some kind of native center?
So you've asked about 5 or 6 different questions.
Yeah, pick one.
I'll try to do them in order, and you might have to remind me.
Okay.
The first one is about what happens now with the $400 parcels, and when I say that the Giddyville and I because they took the property in title under the Giddyville.
Oh,
that's the way they did it. But although it is the Giddyville and upstream group, their interest group, so you're not wrong to say that there's a group. But in any event, they took it with an obligation, and the obligation they have 5 years to be able to sell it and split the proceeds with the city. And by sell, I mean they would come to the city with a development proposal, and because the other approvals have all been basically rescinded by the city, they're pretty much starting from scratch. They have to be able to show the financial strength to be able to do whatever proposal they have. And the proposal itself has to fit within the guidelines of what the federal judgment says. So there are constraints, and they have to accomplish it within the 5 years. That's where we are with that. And at this point, they'd have to go back and get an EIR approved, and they'd have to come and convince this city council that the proposals were meritorious and worthy, and the city council was willing to do that. That's where we are with that. Your second question, I'm sorry, I don't remember, other than saying nice things about Nina.
My question was, is there any way, well, kind of what was going on with the East Bay Park, and is there any way that as a part of either the settlement or a part of the deal with the park, that there could be an indigenous center? I'm not talking about a reservation, but there is a Segoria Land Trust. And could there be a native cultural center with maybe some land that was set up? And yeah, I just want to throw that out there.
Sure. Let me just say a couple of things about what I'm doing and where we are. I don't view it as my role to tell people what there can and cannot be there. My organization, Citizens for Shore Parks, and one of the organizations I represent, Point Molate Alliance, have a lot to say. And I think this is a community decision, and that's what's been missing from the beginning, is the ability of the community to come together and say what they want. And I know that there have been discussions about having some sort of a center that would honor and respect and incorporate the cultural values that the Ohlone brought to the land. And I don't mean to disparage the Giddyville, but the reason that they didn't get the casino finally came down to an opinion, I think it was about 20 pages long, that listed more than a dozen reasons why the Giddyville could not federalize the land and couldn't get a federal casino. So, and the principal reason was that they are a Mendocino-based tribe. And so I'm not arguing that now. I'm just saying that there was a disconnect with regard to which tribe you're dealing with. But in any event, moving forward, the city can have a process and the city can figure out what to do. But I think the two things to look at are the Park District. The East Bay Regional Park District has been contacted by many people, including my organization over the years, for what their interest is. And the Park District has included Point Molate in its general planning and its general plan to have a park out there. So that's part of what's been going on. And even under the what I call the ill-conceived plan that was done with SunCal and its silo Winehaven Limited, they had wanted the Park District to come in and take over parts of their plan so that the Park District would run the open space, and the Park District declined because it was some kind of cut up, chopped up. It wasn't a park. It was basically their development. So yeah, all of that's in the works, and I think that the Park District would like to move forward. It would involve negotiations with the Giddyvilles and upstream to in some way make them whole for what their part of the settlement agreement would be, and those numbers have not been threshed out fully. I hear probably every rumor around that is, and I won't go exploring all of them, but I will say that I do know that there have been serious conversations among the Park District, the Giddyvilles, the city, and even our larger organizations and our interests that brought these lawsuits. And we would like to see some resolution, and I think that there's a path forward. We just need to inch our way there and come up with a sufficient amount of money. The state budget produced $36 million for acquisition and development of a park out at Point Molate. So there is money. There's money to do this, and we need to be of good faith to do that. I think I got through all your questions, yes?
Pam, you're muted.
Thank you. I just wanted to just touch on something in the chat that Jeff Kilworth answered, but Nina asked if they, meaning the Giddyville / upstream, don't do that in 5 years, I think sell the property to your developer, then it goes back to the city. And just to clarify.
That's correct. Yeah, it goes back to the city, and then the city is once again still obligated under the judgment and agreement to try to market it and do the same thing. But that's why when I talk about this this split almost of interest in the place, there is the Winehaven and there is the renovation and the rehabilitation of the Winehaven, where there will be development that will produce presumably economic benefit to the city and the region. And there is the open space park part. So I think that you have the city could entertain a park plus renovation development that would work very well. So there'd be no harm in moving forward with the park aspects.
So I want to go to the next person, but I want to clarify that parks bring substantial income to cities and really are a form of development as well. I just wanted to.
And that is, in fact, there are many studies to show that parks bring an enormous fiscal benefit to the locality where they're located. I'm going to take a 2-minute break if that's okay. I have to get something to drink.
Okay. And Gail Meyer, your question is next.
Hi, can you hear me? This is Tim Laidman on Gail's name because we're partners and we're using her computer.
Oh, okay, great. Yeah, so Robert will be right back. Yeah, I'm glad you got him.
Yeah, I just wanted to say most of my questions are already been answered by the excellent questions that preceded me, but I have a few clarifications I wanted to find out about. The first one being the time frame when that 5 years run out. And if you know that, you can answer it. I didn't write down the date the contract was signed. So
Robert, Tim Laidman is the next person up. And he has Tim, do you want to repeat that question?
He's posing as Gail. Is that what he's doing?
Yeah.
An imposter.
Here, I'm proving I'm really here now. See, and here's
Okay.
Gail. It's not just an alias, it's a relationship. But anyway.
So to answer the first question, yes, it's there. It's not quite a year and a half in. There's about 3 years and maybe 7 or 8 months left. Gativille and upstream to market the property. And then if they don't do that, as mentioned before, it goes back to the city.
You're muted, Tim.
Sorry, now I'm not. During that 3.5-year period, then the Giddeyville / upstream, whatever we want to call the grouping, would have the ability to basically return the property to the city, or to say, we can't come up with a development plan, or to accede to a Parks Plus historical preservation at Winehaven in that time. So there's a possibility that agreement could be reached to do a specific development. Is that a correct understanding?
Yeah, that's pretty much right. I think you can write off the idea that they would just give it back to the city. That's not going to happen, because there is value there, and certainly at a minimum, there's a lot of value as a park. So that part of it can and should go forward. And I think, I don't know exactly. I don't want to step past the things I've picked up in confidence. So I want to be careful about what I say. But I think that there have been diligent efforts and discussions and negotiations about moving forward with a settlement plan. And I think there are a couple of sticking points as to whether the park district and the city will be able to come to an understanding with the Giddeyville upstream group as to removing them entirely from the deal, giving them their share, if you would, of the value of the sale price. And there are multiple ways to achieve that. I think I can explore a little bit of that without violating any comment. Certainly I can tell you what my opinions are. I think that a clean deal, buying out the Giddeyville's interest and the Giddeyville upstream interest, that is to say, they have interest and rights under a federal judgment. So you would have those rights and interests all assigned to somebody for a sum amount. So you'd pay, let's say they wanted to sell for $500 instead of what they paid, $400. But more realistically, there was an agreed upon price of $45 million between the city and SunCal. And maybe that's the right amount. The park district, in order to be able to make a purchase, has to go through an appraisal process by law. And they're in the process of doing that. They've been doing that for quite a while, just to understand the process. We had another appraisal done as well. There are lots of numbers that have been thrown around. I can tell you what I think without revealing any of the confidences I've heard. I think that the $45 million will turn out to be a benchmark for what the value is, or could be, or should be, or maybe less now that we've got this judgment, because there are no approvals. There's no EIR and no consequent approvals of anything for a project. But in any event, assuming the $45 million, if you split that between the city and Giddeyville upstream, they would get half and half. Somebody asked about what's the split between Giddeyville and upstream. I wouldn't venture to suggest a number, because we don't know exactly how they worked their original deal and where all the money came. We know that they've claimed that they spent $33 million just pursuing all of this. So, hard to tell exactly what's right. Nobody's opened the books and done an investigation of all of that. But even just using those numbers, if the city and the park district and the Giddeyville upstream group would come up with an agreement on a number, whatever that is, and allow for more money to be shifted rather than a 50-50 split, more money to be shifted to the Giddeyville upstream to make them whole for where they were, then I think there's a deal in the offing that could be had. There's some discussion of the Gettyvilles keeping hold of Winehaven and maybe developing it. And I think that that's a bad idea. I don't think the city would go for it. And I think it's a bad idea because it will bog down the progress, and they won't get paid and no one will get paid. And the whole thing will drag on for a while longer. And there are other problems with it dragging on that I won't go into now, but let's say that this is the opportune time to figure out how to make this happen and how to make everybody happy or equally unhappy, but willing to go along with it. Some people call a good settlement is when everybody walks away equally unhappy. But in any event, that's the idea, to be able to come to strike a deal now that will satisfy at least enough the Gettyville upstream interest and the city interest and the East Bay Regional Park District interest to create a park and get some sort of planning and suggested path forward for the Winehaven renovation.
Thank you. Jeff Kilbreth. Jeff.
Hi, and same as Tim, Gail's with me too.
Hi, Jeff.
So, I mean, I guess I just have a simple question about the big picture. You know, the mayor, not only was the mayor
Now, which mayor are we talking about?
We're talking about Mayor Butt. I mean, not only did he, do what you talked about picking SunCal when that was a bad idea and not really, it was a backroom deal and who knows why, but except that he's committed to this thing in a maniacal way and developing it. And part of his thing is the historic district of Winehaven. And the way you talked about it, Robert, it continues to keep alive the dream of doing something with Winehaven. So just to play devil's advocate here, if the development couldn't support a nut as expensive as a $6 million a year cost for a fire station, what makes anybody think that any development scenario at Winehaven could support a $400 million infrastructure investment? I mean, these are big numbers, big annual operating cost numbers, or big, initial capital numbers for the infrastructure. And at the end of the day, I just question whether Winehaven Village can be turned into anything and cover the cost of the $400 million, if that would be required. And I don't know whether it would require a fire station. And I would question whether it could support that if it was. But at the end of the day, it seems to me that part of the problem we have in moving this thing along to resolution is there continues to be an illusion, I would call it an illusion, that Winehaven can be turned into a profitable, successful development and cover those costs. And I don't think that the infrastructure stuff, I mean, as you know, a number of us analyzed the operating budget and the general fund impacts and the fire station. But, we didn't do the same kind of analysis. I certainly didn't. I don't know if you did, but I never saw it about, like what kind of development could go forward with a $50 or $75 million infrastructure cost, and what kind of development requires a $400 million infrastructure cost. But at the end of the day, if that could be clarified, and you asked, the city didn't have a plan. Well, that's part of the problem, because the city is thinking, well, we should really develop Winehaven, and I mean, I suspect that the best thing that could happen would be if we bulldozed Winehaven and made it all a park. Call me crazy, but I actually think that it's so deteriorated and so expensive to make that place work as any kind of normal development. I mean, we could have an Ohlone museum.
Yeah.
Yeah.
We asked questions no longer than 1 minute.
Yeah, sorry. Okay, I'm done. You got the idea. There are some developments we could do and others no.
Okay, so my answer is yes, good point. No, I don't want to be cavalier. The proposal that came forward from SunCal, from every economic analysis that I saw, was unsustainable. It just never penciled out. The costs were too high. And I think a lot of people, yourself included, did a lot of work to see how it would pencil out and what the assumptions had to be to make it pencil out. And the only way to make it pencil out was to assume that the price, I don't know why they started calling them price points. It used to be sales price. But anyway, the sales price of the units that they were going to build would be in excess of anything that ever was seen in Richmond so far, and maybe even the surrounding area. And the loans and the financing was so cheap and unrealistic that it could never happen, or the amount of money necessary and the ability to carry that was not worth. So from every angle you looked at it, you either fudged your numbers and cooked your books to make it look like it could happen, or you looked at it honestly and said it couldn't. That, at least that was everything that I had seen. So yes, that's true of the SunCal proposal. There were some suggestions or proposals of other kinds of developments that would be far less expensive to do. They wouldn't generate the kinds of income and revenue that a developer wanted from selling housing, but they would develop regional interest as a draw and an attraction. Whether those, how those would pencil out, how to make them work, I don't think ever it just got short shrift. Nobody ever really put any energy into them to see if they would work. And that was the point I was making earlier. I think that Richmond was shortchanged repeatedly out of the ability to have a planning process where they would look at something that might be viable and attractive and work as a draw. So that aside, going back to Pam's point, which was there are so many studies to show that parks actually produce revenue. And then there's a shortage of playing fields around. And there are lots of organizations willing to pay for the use of playing fields that they would be able to develop there. And we had presentations by people who were involved as ball field operators. That would be another thing, in addition to park, that would be helpful. So there are lots of creative ideas. I just wanted to say that my part, I'm agnostic about many of the various concepts because I don't know enough about them. And I'm certainly not in opposition or in promotion of them. I think what I'm in promotion of is a planning process that Richmond and the community, the wider community, can engage in that would make sense for it. Oh, and I am in favor of separating the considerations of Winehaven from the park. The park can go forward right now. There's no reason that can't go forward. Winehaven may be a more complicated subject. And the reason why I like the idea of addressing the Giddyville and upstream interest and taking that into account and buying all of it out is that will allow them to go on with their lives and not require us to figure out how to solve Winehaven with some contingencies and all of this. Now, it's just going to be too difficult, too fraught for all the problems it brings for collapse again. And so just do a deal, buy them out, allow them to go on their way. That allows the city and the park district to sort out how to move forward.
Thank you. Yeah, we're actually at time, but we have two final questions. And Robert, are you able to take two final brief questions?
Yeah, and I'm sorry that we ran out of time. I would like to hear.
Oh, this has been really wonderful. So I'm glad for all these questions and that you've been able to stay on. Regina, do you have a question?
I have always wanted to understand what the city owns, what the parcels were on the map that the Guideville tribe has and what could be right now be developed as a part of the East Bay Parks? Is the city going to give Point Molate Beach or sell it to, I guess, sell it to East Bay Parks? I just have tried to find a map that shows what the city still owns there, what the tribe did. And
Regina,
and
you can get that map from the city. I'm sorry that, I should probably have brought that so we could put it up on the screen. But if I could just give you a quick little imaginary development tool. There's Winehaven Village, the small print of it, and there are these parcels that are more or less in the flatlands, including where the old drum lot is across from the beach, across the road from the beach.
Yeah.
Basically the flatlands. And they all together, presumably, or at least the argument was that they represent 30% of the parcel, and the rest of it, which is mostly on steep hill, represents 70%. I don't know if it's fair if you were actually to just look at a overhead map from a drone, whether you could count this hillside going up as land, but in any event, without arguing the point, it's the flatlands, the 4 parcels that they were going to develop as for housing, and some part of Giddyville that would be the land that the Giddyville upstream entity own now, and the city owns everything else.
And Regina, you're muted.
So the city now has the land that was going to be developed on the hillside. Did that go back to?
Yeah, there's no, right. There's, well, actually, okay, let me explain this part. Upstream and the Giddyvilles bought a portion of what SunCal was involved in. SunCal had this whole process of development for the entirety. And,
right.
But SunCal is out of the picture entirely now. We're just dealing with Giddyville upstream. And Giddyville upstream only has the 4 parcels they bought, including a bit of basically some portion of the Giddyville village. So that's a much smaller footprint.
Okay, so the the project with the parks can go forward now.
It can, but the park district is not interested in moving forward without a full picture of what the park should be. They don't want to do it piecemeal. They won't spend the money unless they're doing the whole thing. So basically the obvious deal is to leave Winehaven as Winehaven, the Winehaven Village, for later, and to just move forward with the park and establishing the park now. And that would be all the flat parcels that the Giddyville own. You'd take away their interest in the Winehaven Village, and then so the city would be in charge of the rest of it. So the city and the park district can work this out.
Okay. And I would just, with the unreinforced brick structure of Winehaven being, no maintenance for 100 years, seems to me something massively expensive to even do the infrastructure for stabilizing that building. That it might be, but it seems like I can't any commercial project working there. Anyway, that's all.
Thank you, Regina. Thank you, Robert. And Kelly, final question.
Final question. Now I feel more confused than I was at the start. So does this mean, Robert, that all this work and all this fight to stop a big development can really still happen?
I'm sorry, you mean the big development can really still happen, are you saying?
Yeah.
Well, I think that the city's under an obligation to the Giddyville and upstream to follow the rules set down and the agreements set down in that settlement agreement judgment. But the Giddyville have the same problem that that SunCal had. Nobody wants to put down the kind of money to do this as a development. However, luckily for them, the Park District is well funded to do this now. So in a sense, the Park District is the angel here. So I don't think the kind of development that involves a lot of bricks, concrete, buildings, and so on is in the offing, but a big park is in the offing. And then what to do with Winehaven and how to decide to rehabilitate or whatever. There are people who love old buildings and love historic preservation, and they can step up and see what they can do. And there are people who are very clever in how to come in, gut the inside of one of these, keep the shell, and build something inside that people would be interested in. I'm not in that business, and I don't feel qualified to say. I haven't seen the proposals yet. So, that's basically, that would be the process that Richmond would go through. At least that's what I think will be the process. I don't see anybody coming in with some grand big proposal to do what SunCal failed to be able to do.
So when we're talking about the park, if it turned into a park, is that all of the land, like the land that was going to be developed?
I think all but Winehaven.
Okay. All right. That's it. Thank you so much for going over.
Thank you, everyone. Sally?
Thanks to everyone for joining us. Thanks to you, Robert, for getting all of us interested in the legal issues around this, because they're really crucial in terms of founding a park. So Speaking Up for Point Molate is now closed for holiday break. We plan to pick up where we left off on January 8th, which will be 2024. Thanks to everybody.
All right, kids, have fun. Bye.
Bye.